All right, thanks everyone for coming here. It's great to be back, and as this is typically IP speed dating, I felt the need to actually have some sort of profile, even though I am now legally married in Georgia, right? So here's the topic of my paper in the name is sort of method patent exceptionalism, and so what got me thinking about this is that you know, historically, process and method claims have had sort of this questionable validity to them. But in my background, when I was litigating in practice doing pharmaceutical litigation, in fact, method and process claims are second best options, right? In that space, you actually want the compound protection. And so there's always been this odd disconnect that people don't seem to like process patents for, well, no one seems to like them, but for different reasons. In pharma and chemicals, because they don't give you enough protection. In other areas, it seems to be that they're too broad because they protect the intangible. So you've got a patent, which by definition is intangible, protecting something that is intangible, right? So it seems to be this compounding problem. But I don't buy that necessarily. And when you start looking at what the courts have done, you see them creating these odd treatments of method claims in ways that I don't think are justifiable. They certainly are not justifiable by the statutory language itself. Moreover, I don't think they're justifiable by any real policy concern. The concerns that are driving the sort of categorical treatment, negative treatment of method claims can be addressed by other doctrines and other concerns, right? So that's what brought me to this. I'm still struggling a little bit with my normative thoughts on the matter, so this will be great. This is the kind of paper I thought I was really going to work on a lot this summer, and I turned onto something else. So there's a lot of opportunity for feedback, including, Tim, this is idiotic, step away from the project, get away from the podium. All right, so of course the statute itself creates specific provisions that do treat method claims differently. You can't step away from those, and that's because process and method claims are different in some ways, right? So 271G is specific to patented processes. It gives protection to patent owners against the sale, importation, or offer to sell of the product of a patented process. Of course, this is rooted in a rather anachronistic now view of processes as always having a product, right? That oftentimes processes don't have products now. But it is an example where the statute specifically treats method and patented processes exceptionally, but favorably in this context, giving more protection, given the ability to arbitrage territorial lines to avoid U.S. infringement. Related to that, there is an evidentiary presumption that's not invoked much, but it does exist, that the patentee, if the patentee can show that there's a substantial likelihood that the product was made by the patented process, and reasonable efforts were made to determine the process actually used, but was unable to do so, then we flip the burden of proof, right? And at that point, the infringer is presumed to be infringing unless they come forward with evidence to show that the process was not, in fact, used. And of course, most recently, we have business method-specific post-grant procedures that cover business method procedures to allow us to challenge some of the business methods that came out after State Street. And now, in conjunction with Alice, we see a lot of rationing down, obviously, of business method patents. So those are the statutory exceptional treatments, and that's not what interests me. What interests me more is what the courts have done. In the face of a neutral statute, they have categorically said, well, this doesn't apply to a process. And the reasoning at times just seems to always reduce down to the same idea, that these are intangible things, they're just different. And so this is where I just feel it's trouble, particularly when there's things that are utterly inconsistent in the law that the courts have never bothered to try and reconcile. So in particular, the idea of can you sell a patented method? And so in NTP, that's the BlackBerry case, which is sort of more famously known for its extraterritorial aspect, there's this language in there saying, well, we're not going to create an absolute prohibition against the sale or offer to sell of a patented method, but they really walk up pretty darn close to that line. Everything in the decision talks about how, no, you can't sell it, it doesn't make sense, there's nothing to be exchanged. The legislative history suggests that you can't do this. And in fact, TRIPS itself, when you look at the TRIPS provision, the only infringement provision dealing with method claims is specific to the use of the method. It doesn't talk about selling or offering to sell it. So that suggests this Federal Circuit, again, not crossing over the line, but really walking up to it saying this is simply unavailable to method patents, that you cannot infringe by selling or offering to sell the method. But then we have Quanta, right? Quanta specifically says that method claims are subject to first sale doctrine, to exhaustion. So somehow, in the mind of the Supreme Court, there is an act that at least is kind of sort of close to a sale that triggers exhaustion. Right? And it is also quite clear that the on-sale bar applies to method claims and process claims, which makes completely no sense if you believe what the court says on the 271A side of things. Now, they wave their hands and say those provisions are different, but as I've written in the past, how? Right? There's nothing really distinct other than one is an infringement provision and one is a validity provision for treating those two differently, particularly when one is on sale and one is offered to sell. They're basically the same thing, and they have used those interpretations of each provision to inform the other. So it's sort of an artificial distinction. In another area which I need to unpack more since the decision came out this week, and I was reading it more for the extraterritoriality stuff, since that's one of my shticks, is the CMU case, right? Where there, the issue was, can you get damages for foreign sales of a chip when you use the method in the United States? Federal Circuit actually realizes, oh, there is a presumption against extraterritoriality, who knew? And they're saying, no, you cannot get damages for those foreign sales unless they've come back into the United States. But the claims at issue in CMU are method claims. Yet the damages are tied to sales of chips, right? So even here we see a little bit of a disconnect, admittedly on the remedy side, and so I need to unpack this a lot more, and I just haven't had a chance to do so, where we do seem to think there's something sales-like about a method that at least gives you damages, even though NTP suggests you shouldn't be able to do so. Other areas where we treat them differently, extraterritorial treatment, this is really what got me interested in this. Clearly, if you can't sell a patented method, then the extraterritorial scope of transocean is not available to you. That the location of the ultimate sale, not where the offer, drives whether or not there's infringement. NTP makes it clear that you cannot infringe a method claim if any act takes place outside of the United States, but you can infringe a system claim, right? That's the BlackBerry case, saying, yep, they used the system in the United States, but they didn't use the method in the United States because one step was performed outside of the United States. Why the differential treatment? Again, I don't find the reasoning of the decision terribly persuasive. Section 271F, dealing with exportation protection. There, earlier in Union Carbide, the Federal Circuit had said, yeah, it applies to methods. If you export a catalyst that's used overseas in a process, that can be infringement. But then they ultimately step back away from that in cardiac pacemakers and say, sorry, 271F is process claims are categorically excluded from 271F, even though there's no language that that provision is specific to non-process claims only, right? And so, could it be that the presumption against extraterritoriality explains this difference? Absolutely not, because they never mention it, right? They just don't actually bother to apply it. Now, maybe you could say that should be the case, but again, I don't find that persuasive. The divided infringement scenarios also have this distinction, right? And again, a lot of this has its tie to NTP, so maybe this paper is ultimately just discreet against NTP, and I have to accept that, right? But again, NTP makes it clear that you use a system and the location of that use is determined by where the control of the system is and where the beneficial use of that system is. The Federal Circuit then takes that in Centillion and uses that in this divided infringement context. Again, it's a system. So even though in that case, the user of the system didn't own all of the components, there was nevertheless an infringing use of the system that it was whose ownership was divided up because that user controlled the system and received the beneficial use of the system. That's in sharp contrast to the method divided infringement scenario, which we see with Akamai and all of that litigation history, where you have the strong single entity rule. That if any step is performed by somebody other than, if steps are performed by multiple parties, generally no infringement unless you've got the control dynamic, all the debates we saw earlier, thanks to Dimitri, right? again, clear, sharp, differential treatment of how we interpret what it means to use a system versus what it means to use a method, with very little, in my view, policy justification for the distinction. You could easily say, no, use of a method is where the control and beneficial use of that method flows. Like, why the distinction, territorially speaking or otherwise? And so, the one time I think where it makes sense to treat product or process claims differently than system claims is in Section 101 patent eligibility, because that's where the statute actually lists for different types of inventions. Yet the Supreme Court here goes the other way and lumps and dumps everything together, right? So this is a little bit of an odd tag on, but right, basically if the method claim goes down, everything else around it goes down too. That's basically what happens in Alice. And it, to me, is a sharp contrast to how things started to develop pre-Alice. Right? When you see the trilogy of Knighton, Bilski, and was it Comiskey, you had a much more robust discussion of the statutory categories. Bilski is specific to processes only. Then suddenly Alice swallows it all up. And so the one time I'm like, well, this makes sense that we should treat method claims differently. We don't. We actually lump them in with everything else. So what's the takeaway? The so what? Right? Again, I don't think any of this categorically differential treatment of process claims is clear from the statute. I also think all the justifications for treating method claims differently, the idea that somehow by being intangible, they're more problematic, more dangerous, maybe have scope or notice problems, to me that's really unpersuasive. What it comes down to then is, what's the nature of the claim? Right? For a lot of industrial processes, these can actually be fairly specific and fairly tangible. If you think about it, the process of making a chemical, not a lot of abstraction there. It seems more to be the concern of the modern era with the business methods, where you've got functional claiming issues, breadth issues, right? But that, to me, is not a reason to say all of these other protections are simply unavailable to method claims, right? There's a disconnect, a lack of fit between that. It's very unnuanced, and we have other tools to deal with the problems that supposedly attend method claims. And so ultimately I'm still playing with the ideas of how I want to draw this out. Obviously I want to harmonize and eliminate most of the exceptional treatments. I think it might be, you could argue that it's possible to sell and even to make a process if the object that you have made has no other use except to infringe. Right? Ultimately, if I'm buying this plant that's going to make a compound, right, it's probably only going to be able to be used for that purpose. Why do we have to wait for you to use it before you infringe? And so that, to me, becomes important, the temporal dynamic. That by expanding the availability, particularly some of the infringement provisions for these patented methods, you can actually get these litigations going up front earlier. In some sense, this could be advantageous to potential infringers, and this is where I'm just completely speculating, but need to think about it more. That particularly if you're in a capital-intensive industry, so we're not talking software patents, you may prefer to be sued before you've dumped a lot of money into a lot of your capital investment, right? To get that cleared out sooner, get things resolved faster. You could, in theory, the patentee now could bring a declaratory judgment action if there's enough activity to satisfy case or controversy. But I do think, and there's some of the literature dealing with when the offer to sell provision came in, talking about why moving up the timing of the litigation can have its advantages. Obviously it can be pro-patent, but I think there's times it may actually be in the interest of the infringer to get things resolved sooner too. But that's me speculating wildly. So with that, that's what I've been thinking about. Really kind of curious as to what the courts are doing here, and more curious to find out what your comments, questions, suggestions are. So I'll open it up at this point. Or I would just, Dimitri.
Well, I guess a lot of the pushback that I've been getting too is that, well, the patentee chose to draft it sort of this way, you know, if we want it to be a system claim or apparatus claim, we're collapsing it as basically by suggesting sort of these shortcuts for a settlement method is still, so we're collapsing the distinction between, between what we, what we're allowing in the statute rate, and so I think I have some responses to that in my work, but I'm wondering what yours are. The patentee chose to define the right this way, no limitations.
Well, I think there are elements of choice to it, and that there's always that choice, right? The fact that it is every single method or process claim gets this treatment, not just ones where you could have drafted as a system claim, right? So in the, and I guess this is my chemistry background coming to play, there are times when you don't have a choice. right? Your only option is to claim in terms of a method or to claim in terms of a process, right? And so to that extent, then you still just lose these protections anyway. Maybe the pushback on that is, well, there's a reason you don't have that choice, is because the compound's already known or whatnot. But again, those claim drafting choices, one, it's a little circular, right? The reason you may draft these things these ways is because these are the limitations that we know now exist in the Patent Act. So, right, that doesn't, to me, justify why we're treating processes categorically differently. But two, a lot of those choice questions, again, then tie to the claim. And to me, for me, the issue isn't the nature of the method. It is the nature of the language and how you're drafting it, what examples are you write, and those are all just scope issues that we have other tools to deal with. We don't need to say, well, process patents are just simply different in order to address those concerns. Yeah.
Don't you have a similar kind of issue with sales, though, even when you are not talking about process patents, in that we don't call it infringement if you, unless you're offering to sell, the actual patented thing, right? So we don't call it infringement if you offer to sell the patent or if you offer to sell the license. It's until you're offering to sell the patented thing that we. So isn't that sort of similar to the way it works out with processes? That, like, when I sell the factory, I haven't yet sold the infringing process.
Well, see, I think that's a little bit because we accept without pausing to think why, that we say there can only be the act of infringement the moment the steps are performed, right? As opposed to saying, if this, and this gets to quanta a little bit, right? To say, like, if there could be a first sale, what's being sold, even though it's a method, is like, all of this stuff has no other use except to be used in this process. So why wait until something's been built, being used, if we know well in advance, look, we can address this earlier on. Now, the sales stuff also, we've got to step back and realize that you can be infringing without actually having made anything yet as well, right? So as we move on sales and offers to sell, sort of paper infringement, that also makes us have to rethink about what is the nature of what we're trying to say is being infringed. So I get the licensing dynamic in some ways as an unauthorized license, but for me, I may talk myself back out of this, at least on that dynamic, but that to me is the real rub, is like quanta on sale bar, yet 271 offer to sell. Maybe it should be that quanta and the on sale bar stuff is wrong too, right? I have to acknowledge that possibility as well. Yeah.
So two thoughts. One is, I think the factory example, we have an inducement and contributory infringement to already handle those kinds of situations where no other purpose of this plant is to produce the compound. I think we could seemingly to use contributory infringement to get to the same result without having to make the move that you're having to make. So that's my first comment. The second comment is, to me, here's my just innate gut resistance to it. I feel like a lot of these splits developed because there were hard problems in conceptualizing the infringement of the method claims under the existing framework, which largely was system-directed or product-directed, and the courts really struggled. It was different to them from a practical perspective, and so that's why they split it off. They saw some kind of real problem there, and so I guess for me to be more comfortable with the move you're making, I'd want to know, why is it that whatever drove the court to move in that direction, to split off the doctrine for process claims, why isn't that a real and valid concern? And maybe with quanta that's easy, but maybe with some of the other ones, like the NTP example, that's harder.
I'll take the second one first. At least the reasons the courts are giving are just the same trope about method and processes being different, right? And they sort of say that stuff justifies treating it differently without really unpacking why that may do the work in this particular circumstance, right? I think that's particularly the case in NTP, right? Well, processes are different, and they sort of back into the process patent is only infringed when the steps are performed, therefore when the steps are performed outside the United States, necessarily that means it's outside the United States, as opposed to thinking, like the systems claims, why are we talking about where the location of the use of that method is? Fine, something's performed outside the US or by a third party, but who is the user of the system? Why does the fact that it's a method or a system claim in that context make any difference? And they don't really deal with it, right? They kind of say system claims, okay, we're going to march through every part of 271A on the method claims and then say why they don't apply. And for me, that problem of method claims are different. This doesn't seem to do much work there. And then particularly when Centillion comes along and says, even for divided infringement scenarios where you've got the system being owned by multiple parties, that can be infringement. but you still have this strong single entity rule for processes. To me, there's no reason in my mind to treat them differently, at least not by what the courts have said. As for the first question, the contributory and active inducement, I don't know if that does do it, right? Somebody's going to have to be contributing something to that, and you still have to wait for the active infringement at that point, so at least you don't get the temporal advantage. And it may be that there isn't someone who's actually contributing something that has no substantial non-infringing use to that. It could just be somebody who holds it. But I'd have to think about that one a little bit more. My intuition is it doesn't do the work that I think that it would, but I'd have to play with it a little bit more in my mind. So that's a good point.
Minute 30.
Yeah, Charles.
So I think if Sideshow Bob were here, he would say they don't give a Nobel Prize for attempted chemistry. So that's something we care about in tort law that we don't necessarily care as much about or care about differently in criminal law.
Right.
And so I think there's a distributed distinction that you can make that punishing attempted actions on the one hand in criminal law, but not punishing attempted but unconsummated acts that might otherwise be infringing, that's a meaningful enough distinction to base that on. Now, as far as the substantial non-infringing use, I think Quanta could give you the answer, if you take that normative premise to begin with, that a substantial non-infringing use, in the sort of legal realist sense, we only find out that it was substantially non-infringing or not, the alternative use that's asserted, after litigation. So if we're going to allow people to be sued before they've had a chance to innovate and find a potentially non-infringing use for the factory, right? Then you're disincentivizing that by allowing them to be sued up front rather than tinker with. And so
I don't know that that's the case, right? Because if you allow them to sue up front before damages actually accrue terribly much, because think about it, what would be the damages in the remedy for some of these scenarios if you get in there earlier? There may not have accrued that many damages quite yet. And if you get the injunction, now you have the opportunity to design around, or you may even be able to design around while the litigation is ongoing, right? And so I'm not entirely certain that that's the problem. As to the before, after, the first part of the question, we've already taken that step a little bit with offer to sell infringement, right? That we do draw that distinction where the threat of some behavior is actually liability inducing in this context as well.
All right, that's